Welcome to Widener University, Commonwealth Law School. My name is Professor Christian Johnson, the faculty advisor to the Law Review. We're looking forward today to today's Law Review Symposium, Pandemic Practices, COVID-19's Impact on Civil Practice. I will now turn the time over to David Sweetman, the Law Review Symposium editor.
Thank you, Professor Johnson. So I'm going to introduce the moderator today. As Professor Johnson said, this is the Symposium, Civil Practice and COVID-19's Impact on Civil Practice. We all know it's been a crazy year for every aspect of life, but it has impacted civil law just as much as it has the rest of the life. So first we have Professor Lee. He obtained his bachelor's degree from Butler University, then went on to obtained his JD from Harvard University. He has taught at various schools, including the University of Pittsburgh School of Law and Villanova. And here at Widener, he teaches torts, professional responsibility, and constitutional law. I had the pleasure of having him for professional responsibility. And I mean, he is a great professor. So I think you guys are really in for a treat with him as the moderator today. So without further ado, I'm going to turn it over to him.
Thank you, David, for the most gracious introduction. I do feel a little deficient in being your teacher for professional responsibility, having had you begin my introduction by deceiving everyone by saying it was a good experience, but I guess it's okay that you were doing it to be kind. So we'll take that. I was going to begin by thanking all of you for coming, but as the pictures were flashing onto the screen, it was like old home week, and I got so excited because I saw all of these people that I recognized. And so it's not only is it exciting to have people here, because this is like a real drag to have to do this and there's nobody there, but to be able to do this and see all of these familiar faces. And I have to share with you that today is one of my 3 last days of class. And to see all of you show up on one of my last days of class reminds me of why I do what I do, which makes it important to thank you for that, which is I help people who aspire to grow up to be like you, right? I teach people who aspire to grow up and be like you. And when I look out there and see who you are and what you've done with your education, then it makes me feel like, you know what? Maybe there is a point to what I do with my life. So please continue not only to do what you do, but to be who you are. And I will continue to find a purpose in what I do. Also, this is a very exciting day for me because I get to introduce 3 very, very exciting people who are going to talk about 3 very dynamic aspects of our time. Our first speaker today is going to be Tracy L. Updike, and Tracy is a lawyer at Meddy, Evans, and Woodside. Our second speaker is Stephen A. Douglas, who is Associate Counsel for the Naval Supply Systems Command. And our third speaker is Jessica Lehman, who is an attorney at Harding, Hill, Turowski, and James, LLP. Let me begin by I'll introduce all of them in more detail as we go through the program. But let me begin by telling you, as I said, Tracy is a lawyer at Meddy, Evans, and Woodside, where she focuses her practice in the fields of consumer and commercial bankruptcy and creditors' rights, including foreclosures and commercial loan workouts. Tracy represents both debtors and creditors and also handles negotiations with taxing authorities, including offers and compromise. She is a frequent lecturer on bankruptcy topics for both the Pennsylvania Bar Institute and the Middle District Bankruptcy Bar Association. Tracy serves on the board of the Middle District Bankruptcy Bar Association and the advisory committee to the Middle District Bankruptcy Court. She is also on the board of directors for the Dauphin County Bar Association and chairs their bankruptcy section. Tracy earned her JD from Southwestern University School of Law in Los Angeles and her Bachelor of Arts in Psychology from Penn State. Tracy began her professional career working in the entertainment industry in Los Angeles, which raises the question why she came back here. But there is an answer to that, which is that her family and an appreciation for the four seasons of central Pennsylvania drew her back to this area. For fun, Tracy enjoys traveling the world, learning about other cultures, reading, and spending time with her niece, nephew, and canine baby, Coco. Tracy, go ahead.
Good morning. Thank you so much for inviting me to participate in Widener Commonwealth Law's Symposium this year. And it was really difficult for me to try to narrow what I was going to talk about because there's been huge impact on the practice of bankruptcy law from the COVID-19 pandemic. And so I tried to break it down into some sections that were manageable. And I'm going to talk about first the impact on the practitioner, because ultimately it all comes back to us, and then the impact on the practice itself. So the impact on the practitioner, I'm sure everybody in every area of law had some impact technologically. For us in bankruptcy, we've been doing electronic filing for probably almost 20 years now. So the filing aspect, not having physical access to the courthouse, was not a big deal. However, I think a lot of attorneys were not prepared to work at home. And so I know even myself, because of that electronic aspect of filing, I didn't have a high capacity scanner at home to scan documents. I didn't have the capability to do the significant amount of mailing that you have to do when you serve things in bankruptcy court. So the first impact on the practitioner was that you needed to close that gap a little bit and move forward. There were some individual attorneys that were great and they did everything completely electronic and signed things online, but that was really the exception, I think, to the rule. I'm still, a lot of things go electronically, but I'm still a very paper-based person. I have files. I need my files in front of me. So that was an extreme difficulty moving home because I couldn't take 3 big file cabinets home with me. So that was a big impact on being able to get work done. The other is client meetings. Obviously, we do a lot of in-person meetings to assess somebody's ability to file bankruptcy, but then not only that, but to review the actual filing documents later and have them sign it. And you're not able to do that in the middle of the pandemic, especially when we were ordered at home. So, I think like everybody else, we discovered Zoom, but at limited capacity. People had to become familiar. I've been teaching on Zoom all semester. I still know probably a thimble's worth of how to use Zoom. So using it to set up meetings with your clients, also very difficult. And then even if you do, you still have to somehow either physically get their signatures on documents or figure out how to do it electronically. So I think a lot of attorneys were behind the 8 ball on being able to do things electronically. So then the next matter was hearings. How do we do hearings when the court is closed? Well, hearings by telephone in front of the bankruptcy judge did happen previously, but it was really more the exception than the rule. It's for attorneys that are from far out of town, and it just didn't pay to travel into town, or sometimes for convenient purposes. But for the most especially for me in my practice, I'm 10 minutes away from the court. It's enjoyable to show up, to see your colleagues, to present your case to the judge. And it's really difficult to instead just go to the telephone and not really be able to see anybody or what's going on. And that's not even talking about technological issues with the phone calls. My first introduction to Zoom actually was then for the creditor meetings for bankruptcy. They needed to determine pretty quickly how they were going to hold these meetings. because there's statutory deadlines on such meetings in bankruptcy. And it was kind of a hybrid system within bankruptcy court. Chapter 7 trustees hold their hearings via telephone, which then creates another issue about identification. You have to present identification to the trustee, and so we had to figure a way around that. And then the Chapter 13 trustee decided to use the Zoom system. So that was really my introduction to Zoom. But the issue is not just with attorneys learning how to do that, but it's with clients having the capability, and particularly clients that are in bankruptcy may not have the financial capacity to have the kind of technology that they need to participate in the hearings. So it did not run entirely smoothly, but we've been doing it for a year now. It's going better. There is access now to the courthouse. And I think as necessary, the in-person meetings with the trustee were continued agreeably until they could be handled in a different fashion. And then finally, I think the biggest thing for us practitioners is in the Middle District bankruptcy section, particularly here, we're a really close family. I mean, most of the people who practice, this is their primary practice. They don't do a lot of other areas of the law. And so I think we're pretty close, and we're a support system to each other. We have social functions with each other. Of course, all of that was cut off. And I think that was very emotionally difficult for a lot of people. I know myself, like I was going crazy until I was allowed back in the office. And I'm not really a people person. I don't talk to people every day at the office, but just knowing that another body was in the building was very important for my mental health. And so I think we're still really striving to try to set something up to get together and reconnect our bar. So I think there were a lot of impacts on the practitioner. But the impacts on the practice, I think, are even more significant here. The vast majority of our continuing practice is Chapter 13. And Chapter 13 is all about debtors using future wages to make payments to their creditors under a confirmed plan. And the problem is, the vast majority of these people had some type of interruption of their income. So it led to a lot of work needing to be done for cases that have already been filed and approved. We had things we could do like suspending plan payments for a handful of months, but that's really only a temporary solution. Another thing was plans that are based on people making money, having a lot of money as opposed to a lot of assets, or being behind on mortgages or car payments. Those payments that were only based on income, we could go in and change those plans and say, look, the income's lower now. This is what they can afford to pay. But that didn't help us for the vast majority of Chapter 13 cases, which are people that were behind on their mortgage and up for foreclosure, or behind on their car payments and facing repossession, behind on their rent and needing to catch up to not be evicted. And so thankfully, the CARES Act, the Coronavirus Aid, Relief, and Economic Security Act, provided significant amendments to the bankruptcy code, and very welcome in my belief. Among other changes, there were little changes like what is income, not to include stimulus payment, and particularly some changes for small businesses that were very important. The CARES Act had special provisions for Chapter 13 cases, and this allowed any cases that were approved by that March 27th, 2020 date of the CARES Act to extend the term of the plan to an additional 2 years. So something very significant, that people were always required to have a plan 60 months or less. And now all of a sudden there's this option to extend it out to 84 months to make the required payments. And really the only distinction is they had to be impacted directly or indirectly by COVID-19 or the pandemic. And I think the thing is there, it's going to be jurisdictional, how that's defined. But here, I think in our district, the definition is pretty much everybody has been at least indirectly impacted by the coronavirus. The ability to get groceries and the expense thereof. So we've really been able to change people's plans and re-amortize them to make lower payments if they need to, by indicating impact. And that CARES Act was set to expire on March 27th this year, but it was extended on March 27th by the COVID-19 Bankruptcy Relief Extension Act to March 27, 2022. So now we have more time to assess where people are at to make payments. And they rolled in the new people whose plans haven't been confirmed since March of last year up until March of this year. Now they also have the ability to extend it out 2 years. So that had a very significant impact on current bankruptcy cases. And then the last thing I'm going to mention before we move on is the mortgage forbearances and the rent rebates. So mortgage forbearances were also addressed in the CARES Act. So as I told you, a lot of these debtors are making payments in a Chapter 13 on back mortgage payments. But what if they can't make their current mortgage payments? It doesn't really benefit them, and they still may lose their home. So the CARES Act provided essentially automatic forbearances to any federally backed mortgage loans for somebody who had hardship from COVID. And that was for 6 months, and then they could extend up to another 6 months. And so that was something that was very helpful for people that were in bankruptcy that couldn't afford their current payments. But we don't know what that's going to lead to in the future, because at the end of the day, they either have to catch that up in a lump sum or hope that the lender's going to give them a modified mortgage. And you know, the government suggested that, but did not require that. But then the last option is we can try to go in and modify their plan again and add back those post-filing payments that they got behind on their plan. So it really, while the current practice slowed down because people weren't able to get out and see their attorney and get their financial information together, maybe couldn't afford to file bankruptcy right now. It really kept us busy with a lot of the cases that were already filed and were having trouble. And then the last thing I'm going to mention is rent rebates. This certainly helps our clients that do not own homes, that were renters, to be able to get some rent rebates under the Emergency Rental Assistance Program. So all of those things have really created an impact on the practitioner and the practice of bankruptcy as far as our current Chapter 13 cases go.
Tracy, thank you very much for getting us through a lot of territory in a short amount of time. Our next speaker is, as I said, Stephen A. Douglas, who, as I mentioned, is an associate counsel for the Naval Supply Systems Command, which is, if you were not aware, an entity with 12 locations and a worldwide workforce of more than 22,500 military and civilian personnel. The command is headquartered in Mechanicsburg. Stephen's primary focus is on civilian personnel law and litigation, government ethics, and information technology licensing and data rights. Stephen received his JD from Case Western University, Franklin Thomas Bacchus School of Law, where he was the associate research editor on the Case Western Reserve Journal of International Law. Stephen graduated locally from Elizabethtown College here in Elizabethtown, PA, with a Bachelor of Arts in Political Science. He was an Army judge advocate after graduating law school, and his last duty assignment was the Chief Trail Counsel for the United States Army Training Center and Fort Jackson. After leaving military service, Stephen worked for Thomson Reuters in the Westlaw Division. Stephen was also civilian attorney for the United States Army Corps of Engineers in Baltimore prior to assuming his current position. Stephen is admitted to practice in Ohio and is a past member of the South Carolina Bar. Once more, someone who was drawn back from exotic places to his central Pennsylvania roots. Stephen, go ahead.
I'm required as a federal attorney to basically say that under Title V of the Code of Federal Regulations under Section 3601. My appearance here isn't authorized by the Department of the Navy or the Department of Defense, and the statements are not communicating official DoD or Navy policy. The opinions are my own, and I don't necessarily speak on their behalf or even the installation's behalf. Most of what I will say, however, is based on current federal law. In approaching this topic, when I was asked to do it, I've kind of broken this down into sort of 3 chronological phases that we went through. We have a fairly varied organization. My installation is a little unique. Most military installations throughout Pennsylvania and elsewhere are exclusive federal enclaves with some limitations. In Pennsylvania, for example, under I think it's Title 74, Section 120.2, the state has ceded all jurisdiction by and large to the federal government for the physical footprint of where I'm located. So a lot of the state laws and state regulations generally don't apply to us, although they impact us. So for example, when I'm talking about things like the Disability Acts, those apply to us through the Rehab Act. They don't actually apply to the federal government. Approaching it chronologically, with the initial onset, I think like most organizations, large companies and everything else, we were kind of on our back foot a little bit on this. It evolved fairly quickly. We had information, I think maybe a little bit sooner, but maybe only a week or 2 sooner than the rest of the general public. Things for us kicked off with the USS Theodore Roosevelt when they had an outbreak of COVID. And essentially we had to do a lot of things with that. Some of it was finding housing for them, but the other was how do we handle dependents? How do other things occur, especially with the civilian workforce supplying them? Initially, we were faced with transportation and travel issues, as well as having our people come into the workspace. We issued our initial guidance probably in the middle of April, it's about April 20th, which serendipitously was about the same time that the EEOC guidance came out on processing of claims. That's the administrative aspects of how we were going to do things. A lot of that guidance is available at the EEOC website. If you're a practitioner trying to plead in front of them, they will occasionally get really sticky on their rules. And some of those vary by location as well. With respect to transportation, we probably have, I think, a little bit more control over our civilian employees than other companies and entities, but there were huge issues with where people were going, how they were transiting. One of our councils in Mechanicsburg was actually caught and quarantined in Tokyo. He was coming back, and if you were transitioning through Japan during that week, the military authority there basically just said, now you gotta wait 10 days until you're clear. That was inconvenient, especially if you don't have connectivity, don't have access to computer networks and those kinds of things. The practice that I work in also has to coordinate with a variety of other organizations. I represent a subunit of the Department of Defense and a subunit of the Navy, actually. So coordinating across all of the various commands, Army, Navy, Air Force, and in some instances, the U.S. Coast Guard operates under Navy authority, was challenging because we sort of needed to have a unique single approach throughout the Department of Defense. But you've got a lot of people out there that sort of want to do it their own way, and that creates some challenges. We also have the added adventure with some of the allocations of status of forces agreements with host nations. These are called SOFAs. The SOFAs dictate quite a bit of personnel policy, access, transit, how people get to and from work. When Italy shut down, we have locations there. That became a challenge to get our people who needed to be at military installations actually to be able to transit and do certain things. And then that requires a negotiation with foreign entities as well as NATO. The other big thing is the how we handle dependents. everything from the daycare to moving people, civilian attorneys transiting, or just civilian personnel transiting their families. There was a freeze in place for several months, which was designed just to contain COVID. Throughout all of that, the Navy still is at least this organization is a supply chain. And we need to make absolutely certain that whatever we need to get downrange gets there, timely, legally, as well as the ability to, move things to and from. In my particular practice, I have unions, and they're covered by the Federal Labor Relations Act. The FLRA, like the NLRA, basically has some unique set of rules of how you can change policies and do things. Fortunately for us, most of the COVID rules were DoD-wide, and that's an agency-wide regulation, so we really don't have to bargain over those regulations or those changes. We do, however, have to what's called impact and implement bargaining, which is how are we going to execute this? We've closed the gym. We no longer have the auto skills hobby shop open. These are changes that we need to coordinate with the union. We have adopted what's called weather and safety leave for individuals who can't come to work because of some underlying condition. They can't be exposed, they can't risk everything else. And these are legitimate medical conditions. Nobody wants to really get hurt. But how that's implemented with bargaining unit members is a subject to I&I bargaining. Fortunately for us, the unions, by and large, if you let them know what's going on, don't really have that much of an issue. It's when you fail to let them know what's going on is that they then become much more engaged in the process. And we'll either file a grievance or seek arbitration on something. We've been fairly lucky on that. We've done some things, and frankly, the union said that, yeah, okay, that's fine. We're not trying to kill anybody here. Once we kind of got through the initial hump on this, we ended up in a full shutdown, which required additional bargaining and those kinds of things. We also have some unique requirements being a DoD organization. We can't use Zoom. There is something out there called Zoom for Government. We're primarily not even allowed to use that. There are Privacy Act concerns that apply to us, as well as, Zoom was hacked early on. They took responsibility for that, full marks, but primarily we use MS Teams because it's behind our firewall. That created a heck of a lot of problems with administrative hearings and appearances before judges and those kinds of things. Some of that was relaxed, but some of it practically, the judges have pretty much, at least in my practice area here, which is Philly, DC, have utilized telephonic conferences quite a bit. But you run into problems with how do you handle deposition? How do you handle documents in a deposition? These are the kind of day-to-day questions that come up. With respect to how that works, I would recommend you take a quick read. There was an ABA formal opinion that was issued March 10th. It's opinion 498, and it is, confidentiality issues associated with remote practice and those kinds of things. Would have been really helpful if it had come out March 10th in 2020, but better late than never. The reason that you need to be careful of these kinds of things as a practitioner is that even in the federal government, we are governed by our state bars. So if you violate a state bar provision and get yourself suspended or disbarred or anything, you're out of a job at the federal level. Imagine that times 50. And that's kind of what we have to manage. And this gets into one of my roles as the ethics counsel, is keeping everybody on the straight and narrow on professional responsibility. We take it very, very seriously at the federal level. It's not something to screw around with. We fortunately don't have to worry about IOLTA accounts, but pretty much everything else comes into play on that. As we got into the shutdown and everything else, we had a whole bunch of issues with people who were claiming medical disabilities, wanting short-term work at home situations, and then also issues associated with the various technologies that were utilized. In our case, remote work is this term of art, but essentially if we permanently assign somebody someplace, that becomes where they're paid from by law. It's an operation. So how do we get around that? Equipment, who provides it? Access, who pays for the cable? And then at the federal government, at least, if you're on telework, you have to fill out a questionnaire for safety in the workplace. We mercifully have not had, I think we only have one federal workers' comp claim right now, but that is an issue in a home office. If you're directed to work in a home office and something goes wrong, are you going to have exposure for workers' compensation? All right. One of the other issues that we run into in federal practice is who's going to pay for this and how. Federal government is governed by the Anti-Deficiency Act, which basically says that all appropriations must have a purpose, a time, and an amount. And you cannot mix one type of funding with another. So that's an added challenge at the federal level to make sure we're paying people out of the right bucket of money. Because if you pay them out of the wrong bucket of money, it's one of the few areas where you have personal liability. And there is a web page at the White House for all the people that did things they weren't supposed to do and now owe the government hundreds of thousands of dollars that comes out of their pay. So we try to make sure that none of our managers have that issue. All right. So as we transition through that, we also ran into things like state and federal jurisdiction, things like worker unemployment compensation, coordinating with the state on certain issues. We're a federal enclave, but if either party gets ahead of the other party, that can create friction, and it can also create some union activity. In terms of the actual practice before both of the Equal Employment Opportunity Commission and the Merit System Protection Boards, it's been a bit of a scramble. So far, we've been successful in doing that. The big challenge comes when we don't have somebody that wants to use the electronic filing systems. Both the FedStep and the e-appeal for MSPB work pretty well as document repositories, and are fairly easy to get access to. The issue then becomes, how do you schedule a hearing? How do you get people linked up? How do you get just the normal technology to do that? And do it in a secure manner so that you're not violating Privacy Act rules, those kinds of things as well. There are issues now that we're facing that are coming up with reopening. All right. And some of these are pretty obvious. Can I be forced to come to work? Must I be vaccinated? How do I handle those kinds of things? But some of them are a little bit more subtle. For example, if you order people to come back to work and they're in a cubicle farm, how far away do I have to be from my neighbor? What if I have pre-existing conditions? What if I have a religious objection to getting the vaccine? Can I then be ordered to come back in? We don't know how that's going to play out, but that's a fairly substantial worry from senior management here all the way up to Admiral Stavropoulos, in that we suspect that we're going to see an increase in reasonable accommodation claims and how we're going to handle those things. The other thing that comes up is, how clean does the workplace have to be? That is a union concern. That's an employee concern. How often are we going to wash things? Are we going to require masks? We had an issue early on where we had limited access to employees that absolutely had to be there to load things out, taking temperatures of people that come in. Well, if you get an automatic machine to do that scans you when you come in, what happens to the data? All right, how is that retained? Is it retained? Those things. And again, throughout all of this, I'm trying to make sure that my labor relations people are one step ahead and letting the union kind of know what's going on. Again, if they know what's going on, they're very happy people. If they don't tell them, that's when we have an issue. Probably the other things that are coming up for us is we're not Pollyanna enough to realize that we don't have people that are teleworking from home under emergency conditions, and then when they get on the Zoom meeting or the Teams meeting and that kind of stuff in the background there, you can see the Jersey Shore. that is not their duty station. I understand that people like to live, you know, and work on the shore and those kinds of things. The other issue then comes up is what happens for tax payments. Where is the taxable entity at that point? We're working on that. Federal blue rules are if you're stationed there, that's fine. But if you're not stationed there, you're working there. That's okay as long as everything goes all right. But if somebody's injured, somebody gets into a car accident, you know, the kind of things that keep labor practitioners awake during the night. I think the final thing that I probably would talk about, or two things actually. The biggest question we get in any town hall that we have is, are vaccines going to be required? All right. And the answer is, gee, I don't know. That'd be really great if the Department of Defense tells us that. We don't really know if that's going to be the case. These vaccines are still in the sort of the limited use phase. They haven't been fully approved yet. So again, I would, the start of all of this, if you really want to look and deep dive into the law, is a case called Jacobsons versus Massachusetts. It's 197 U.S. 11. It's a 1905 case, which is pre-Lochner for those constitutional scholars. And basically, the federal government says, yeah, you can require vaccinations. Since then, there's been a lot of activity recently. You have the Roman Catholic Diocese versus Cuomo on churches being closed or open. And you also have a few others that are out there that you can take a look at. Two others that I would kind of add is there is an Eeoc versus Bay State medical case where basically they make a distinction between the fear of obtaining a vaccine or of being exposed to Ebola in that case versus you know, actually having that happen. The fear is generally something that you can't use as an Eeoc basis on that. And then the other is we've seen a couple of magistrate cases that have come out where characterization of what you're doing is very, very important. So wearing a mask, for example, if you characterize it as a piece of safety equipment, and I don't know if NIOSH was going to come out with anything on this, but basically the courts won't look at safety issues. They're going to sit there and defer to that. Plus, there's a little bit more deference we have as DOT. On the other thing, the only last thing I would add here, time running out, is next week, the EEOC is actually going to have an online Zoom hearing that's going to talk about a lot of this stuff. That's the 28th at 10 in the morning. They're going to publish links early next week. And I would encourage everybody who's trying to gain some wisdom to log in and see if they've come up with anything. So that's it.
So I was just saying that although this is not about me, since I get to moderate, it is about me. So this is like show and tell for me. Because our next speaker is a former student, Jessica Lehman. As I mentioned, Jessica is an attorney now at Harding, Hill, Truancy, and James, where she practices in the areas of commercial and residential real estate, divorce, custody, child support and alimony, business formation and advising, and estate planning and administration. Jessica is a member of the Pennsylvania Bar Association, secretary of the Columbia Montour Bar Association, and a licensed title agent with First American Title Insurance Company. Jessica has volunteered with Mid-Penn Legal Services and served as the Third Circuit Director of the Federal Bar Association. Her research on the history and constitutionality of the death penalty has been published in the Federal Lawyer magazine, and Jessica has taught classes on real estate topics through the National Bar Institute. Jessica is a graduate of Bloomsburg High School, Lycoming College, and Widener Commonwealth School of Law. While at Widener, Jessica started Widener's chapters of the American Agricultural Law Association and the Federal Bar Association. Jessica also received the Outstanding Service Award and the James S. Bowman American Inn of Court Award, and was recognized as the Student Bar Association Representative of the Year and the Student Bar Association Leader of the Year. Jessica, thank you for speaking today.
Thank you so much for the introduction, and thank you everyone for having me today. I'm so glad to be back at my alma mater, although virtually this time. So today we're just going to talk a little bit about kind of the small town practice. As you can tell from my introduction, we do a little bit of everything. I am based in Columbia and Montour counties, which is kind of north central Pennsylvania, so to speak. So we're just going to kind of talk about 3 areas that I practice in, and I'll share my screen with you so we can take a look at that. Okay. Can everybody see this okay? So the 3 areas we'll discuss today are the impacts of COVID-19 in family law, in real estate, and then in corporation and small businesses, because I do a fair share of that as well. The majority of my time, I would say, is spent in family law, so we'll spend a little bit more time there than we normally would. So family law is a classification where I do divorce, support hearings, custody, alimony, kind of everything that's wrapped up in there. And we also do a fair amount of work with children and youth here in Columbia County. So just kind of a culmination of all those put together. So family law in Columbia County, we've experienced an increase in truancy here. It has doubled, and some figures have even shown it's COVID-19 pandemic. And part of that reason is because everybody has moved to online learning. And so the online learning is not as well attended as the in-person learning, and that's leading to this increase in truancy as a result. One of the other big issues in Columbia County for both children and youth and for the private practice of family law is visitation. With regard to the private area of family law, custody, there's been, let me back that up. The courts have come out and said that COVID-19 is not necessarily a justifiable reason to withhold a child from a custody order. Johnny to mom's this weekend just because I'm scared of COVID-19. Now there are some smaller nuances in there, but we won't get into all of that as far as whether or not there's elderly family within the home or high-risk individuals. So as far as in-person visitation in the private world of family law, it has stayed mostly intact, thankfully. Visitation concerns with regard to children and youth cases or child protective services cases has changed, I would say, relative. They have been doing Zoom visits or telephone visits for a number of months, and especially if one of the parents is incarcerated, because the concern with removing a parent from incarceration to visit with the child and then returning them to incarceration is that they take the COVID-19 virus back with them to the prison. So that visitation has changed pretty significantly for in. And then just generally, the custody orders themselves have remained generally the same. We haven't made a huge amount of changes as far as adaptations for COVID-19. Like I said, most of the visitation is still occurring in person, which is good because we'll talk about some of the studies going on right now with child development and the impact of COVID-19. So they need to see people. And I think Tracy touched on this as well. We can't just sit, in our homes by ourselves forever. We're used to being out in the public and seeing other people's reactions. And it's having an effect on development of the children. Children are attending school mostly virtual. At least in this area, they are beginning to move back to in-person instruction. In some cases, it's only a few days a week, or they're divided up into teams and they return to school. Some people go Monday, Tuesday in person and do the rest of the week on Zoom, or vice versa, so that there's not everybody there at the school at the same time. So just something to keep in mind. And then one of the big concerns, especially early on and continuing today, is the prevalence of child abuse and neglect not being detected. Child abuse is typically reported or determined when the child goes to school. The teachers are very good at picking that up and reporting it. And while children remain in the home, no one is there to report that child abuse and neglect. So we'll talk a little about that as well. So there's effects on development for the children with regard to family law, and something that we need to keep in mind. And I think it's increased everyone's stress, but also especially on children who like to, play, go out, have fun with other kids. And so it's just something that is causing them additional worry. And they're doing all of this online, which is another thing. I know it took a while for us as attorneys and as adults to adapt to it, but then the stress of that on children has also been pretty substantial. And they said that this is caused by the increased screen time, changes to the routine, limited physical activity. There's no more recess. Everybody's just sitting at home in front of the computer for the most part. The lack of social life, exposure to possible disharmony at home, and then sometimes unhealthy diets. I know when we probably went to school, we didn't think that the school's lunch were all that great, or maybe you did, but either way, they were balanced meals, and sometimes people don't have that available at home. So something to keep in mind. There was an interesting study that compared the COVID-19 pandemic to the H1N1 pandemic of 2009. Granted, H1N1 was not as far-reaching maybe as COVID-19, or the regulations themselves weren't as far-reaching, but in 2009, approximately 6.2% of children were diagnosed with PTSD as a result of the pandemic's effects. There hasn't been a similar study performed yet with regards to the effects of COVID-19, although I'm sure that there's one coming shortly. And there was also anxiety being the most commonly diagnosed condition as a result of that pandemic. Some of that anxiety was then just the concern of going out in the public after the regulations eased up. So there have been some positive impacts with regard to family law. There's been increased work flexibility for parents and the ability to work from home and spend time with the children at home. So that's definitely been a positive impact for everybody, that there's less activities occurring. You could look at that as both a positive and a negative. With the less activities occurring, the children are able to be home more. There's more time with the family. However, they're not getting that time with their friends to run around, to play sports, and do that sorts of things. In Columbia and Montour County, we're seeing some faster hearing schedules for family law because all of our hearings are currently, I shouldn't say all, most of our family law hearings are on Zoom or by telephone. They are still having in-person hearings for certain items like PFA hearings. And about 2 weeks ago, we moved our custody conferences back to in-person hearings. But for the most part, things were actually moving, I would say, more quickly, or they were still moving at a significant clip because of the use of Zoom in our area, which was very helpful. Limited travel to and from court saves time for both you and your client, because everybody can kind of do it from the comfort of their home. And so that's definitely been a perk. And parents are noting a closer bond to their children. There was a study that found that 68% of fathers indicated that they felt closer or much closer to their children since the start of the pandemic. They only studied fathers in this. They did not include mothers. So unfortunately, I don't have that statistic, but just kind of an interesting tidbit. There's definitely been some negative impacts with regard to the family law system, and that's the inability for the children to access external support systems. Their guidance counselors, after school programs in schools. There's been a prevalence of malnutrition because they're not getting those balanced lunches at school at lunchtime. The possibility of domestic violence within the home is also a consideration because they can no longer go report that to the outside unless they do it over Zoom or over some sort of technology-based program. In March of 2020, you could see there was a 53% decrease in ER-related visits that were related to child abuse and neglect. And so, like our original concern, some of that might be retained within the home. And then by week 13 to 16 of the pandemic, the decrease jumped to 72%. So even less referrals to the ER for those things. There's also been some developmental and bonding delays. Interestingly enough, a baby's brain reaches half the size of a full-grown adult within 3 months of birth, and it doubles in size within the first year of life. And so there's a really interesting study done, and I'll just put these up, and it said that babies can differentiate between expressions within 3 days of birth, and that face masks are actually affecting that because they can't see anything from the nose down. They're not seeing those expressions actually happening, and so they're having a hard time responding to them or recognizing them other than their parents' expressions. They're still doing that bonding because obviously the parents aren't wearing face masks around the children. And then there's some issues with access to technology. As far as Zoom hearings in our area, we're pretty rural, and some people don't have internet at their homes. In those cases, a lot of those clients still have to come into the office, and we do it from my office or over the phone, whichever is possible. So just a couple things on our county COVID practice here. We've been using electronic technologies. They've delayed all of our jury trials for all of the criminal dockets until the end of September, which is definitely questionable still. You can do scheduled appointments. We've been doing scheduled appointments over Zoom or over telephone, as that's easiest for clients too. It does save them a trip to the office. There's also no guests or additional parties allowed in the courthouses. And this is similar for both Columbia, Montour, and I also looked at Lycoming and Luzerne. And they have similar practices all across the board there. And our county here in Columbia and Montour, we're a linked county, and they've come out and said that we should continue to use technology if it's helping even after the end of the pandemic. So just something to keep in mind. Now just briefly touch on real estate sales here. In the spring of 2021, we had the lowest housing market supply in history. It's been one of the most predominantly sellers markets that we've ever had. There's been record low interest rates, and prices of homes have increased 10% over the last year alone. The average gain in home value is $26,300 per homeowner since the fourth quarter of 2019. So pretty significant jump in real estate sales in that area. And so I won't spend much time on this, but one of the big things that's coming down the pipe is notary. Both electronic and remote notary was a big thing during the pandemic, something that you had to be approved for, licensed for, to do in advance. And so that became kind of a pinch point as far as real estate sales. We had to do some splitting of the transaction altogether, bringing buyers and sellers in at different times, keeping them in separate conference rooms. The banks were not attending closing, so the attorney or the closing agent was doing the bank documents as well. In a lot of cases, we did not have the realtors attend either. And so that was to kind of keep down on the people in the office. With that, I'm just going to jump ahead here. Let me do one, and then I'll put my resources up. The last thing I do is small companies, small businesses. And one of the big things that we saw an increase was the PPP loan applications. Everyone trying to find the documents that they had made. If they had made the company a number of years ago, they were looking for documents to submit. And so just interestingly enough, in a survey of 5,800 Pennsylvania small businesses, they determined that 1/4 of small businesses only have enough cash on hand to survive a 2-week shutdown. And then the other 3/4 had enough funds for 2 months or less. So it put a lot of businesses in a really tight pinch, unfortunately. But the PPP loan applications thankfully went out pretty quickly, and there was a couple rounds of them as well. So it's just kind of a really interesting process. Okay. And then my resources are here at the end. So thank you.
Actually, I had a question for Tracy, and the rest of you want to jump in. But you mentioned changes in terms of technology to isolation. How much of the change that you've had to see being made in the present do you see carrying over into the future in bankruptcy law?
As far as the technology, I think it's probably going to be like everybody else. We're going to move to hybrid. But I think the biggest impact on our future is we don't know what the future beholds. I mean, COVID itself had a huge impact 40% decrease in bankruptcy overnight. And as I said, is that because people couldn't get to their lawyer's office or they simply have more pressing matters? But I think a lot of people thought, well, this is going to hurt everybody's pocketbook. Bankruptcies are going to skyrocket. And the fact is they are still really low. Right now, in March of 2021, we had a 34% decline in filings from March of 2020. And you know, we have to climb at least 40% to get to pre-COVID levels. And even then, we were on a downswing. Our practice goes up and down. And the expected wave of business bankruptcies just really, at least in Pennsylvania, has not bore out. Business bankruptcies were down 30% in 2020 from 2019. Year to date, they're down 84% from 2020. So it's not coming back. And the problem is, as I indicated earlier, a lot of our practices focus solely on bankruptcy. And so if the business is not there, what happens? Well, foreclosures have really just started again. And already, finally, April looks to be good. We're at about 15% deficiency than we were this time last year for April, versus the beginning of this year, it was 40%. So foreclosures come, unfortunately, for homeowners, but that means we'll have business again. But then the question is, are we going to have the infrastructure to handle the business that there's going to be? So, you know, I think it's feast or famine in this business. And, you know, I think a lot of us are just trying to survive at this point.
Any questions from the audience? One other question that I have then before we wrap this up, and again, Tracy, it goes something that you said, but I'd love to hear from all three of you on this. There is this isolation, this we're communicating through Zoom. And I always have thought of practicing law as a very relationship dependent practice, or relationship dependent profession. Is the fact that we're not interacting so much as lawyers ultimately has it affecting the practice now? You don't have those relationships to draw on. Do you see it affecting the practice of law in the future as we go more and more distant?
My personal experience is, especially dealing with junior attorneys coming into CPL practice, I've actually had quite an uptick in interaction with them, because they're not able to kind of ask other people. So there's more of a trend for them to reach out to, I'm identified as a subject matter expert. And that's been very good for my practice, because I've been able to work with younger attorneys new to the practice. This is a fairly high level acuity practice. And I think head off some things and also develop some relationships. Kind of a pain over the phone or in a Teams context, but there is somewhat of a silver lining to it.
I don't know if Jessica has anything to say. I don't want to cut her off, but what I would say about it is, as I said, the bankruptcy bar is fairly small, tight-knit group. And the benefit of that is the collegiality in negotiating arrangements when people work on both sides of the aisle. I mean, I always say the hardest case I ever had was against one of my best friends. You don't take it personally, and we work well negotiating against each other. And I think the more we're removed by Zoom, the less those relationships flourish, and the less you're able to do that. So that's the one thing I fear if we never go back to 100% in person.
Yeah, and I would just, kind of mimic what both of them said, because I think they're both right on the money. And it's hard, especially, I mean, I'm a relatively young attorney, and I depend significantly on talking through problems with other attorneys. And sometimes that's the best way to solve the case or to settle the case. And to call somebody on the phone, it's good, but it's just not the same. And so hopefully we'll get to go back and go to, and even the conferences and things like that in person at some point, because I think that's really where you meet people and network.
Well, I want to thank all of you for coming. I see that we're coming to the end of our time together, but a couple things. One, You've got a couple of comments from Joy in the chat room. Make sure you check those. I think she's also going to be emailing you because I want to make sure you get credit because you earned it. I want to thank our speakers for doing a wonderful job today. I also want to thank David for all his work on the program, Joy, Brian, Dean, Johnson, the law review. And again, a super, super big thank you to all of you. As Tracy and Jessica were talking and Stephen, one of the things that jumped out at me is when the rest of the world has problems, their problems get bigger, we get busier, right? Which means that what you're doing every day is you're taking the most important problems in other people's lives and you're helping them find a way through those problems. So thank you so much for what you do every day. Please keep up all the good work and stop by and visit us here in Widener whenever you can. Have a great day. Take care.